cash bail and to implement new policies with the explicit goal of ending mass incarceration and bringing balance back to sentencing. So that was a prosecutor. And we're also really stoked to have Simmi Kaur here, who was Simmi Kaur, sorry, butchering your last name. In the House again, as she was once the president of Harvard Defenders, for those that didn't know, and is now an attorney with Bronx Defenders. Bronx Defenders has radically transformed how low-income clients in the borough are represented by actually getting to know their clients as individuals and crafting representational strategies that account for all of their clients' legal needs, from housing court to family court. And Bronx Defenders and their groundbreaking, nationally recognized holistic defense program are bringing real and lasting change to these communities and shaking up the system along the way. So we're going to look at both of these organizations tonight. We're really excited to have both of these folks here to talk about some of their insights and their own experiences and to look for some point of connection between these two traditionally adversarial roles. But first, we're going to invite our supervising attorney and our fearless leader, John Salzberg, up to speak about the fellowship and the Litman family, who, through their generosity, allow us to produce this fellowship and this symposium and keep our work going year-round. John. Into them, yes.
You can tell me if you can't hear me. So if Jack Litman were here today, he would really be trying to encourage everybody to pursue being criminal defense lawyers. And he'd be really proud of our two speakers for what they do and what they have contributed to the criminal justice system. I think he was very concerned that people would come to Harvard Law School and think, I can't really make a reasonable living doing criminal work, so I'm not going to do that. And the message that he always wanted to convey when he would come here and speak to students at various events was that you can make a living doing this work, and it's great work, it's worthwhile work, it's exciting. And I think he would have been really excited to see exactly how many of you are interested in doing this work. Now, since I knew Jack, I didn't know him particularly well, but I knew him enough so that I could say a few things about him. It's worth it to, I was just taking a look in preparation for tonight at what it says about him on the internet. So here, just reading the beginning, in Wikipedia. It says, Jack was a criminal defense lawyer most famous for his, quote, blame the victim defense of Robert Chambers Jr., the preppy killer. Just what a great example of how, the Wikipedia, the press, everything just tortures the truth amazingly. I don't think that was really a blame the victim defense. What it was actually, I don't know if you're familiar with the case, but it was two, quote, prep school kids who were in Central Park. And what sadly happened was that Jennifer Levin died from strangulation, supposedly at the hands of Robert Chambers. And when the police came upon the scene, one of the things they did was they trampled over all of the evidence. So they really ruined their own case. And what Jack did, from my discussion with him, was he really attacked the police work and elicited things in the trial that kept the jury out for days, to the point where, even though the government was pursuing a first-degree murder charge, they offered Robert Chambers a plea to manslaughter and a 5 to 15-year sentence, which Jack, when I talked to him about the case, really had regrets that he even took the deal, because I think he thought that he could actually win the case. Like any good criminal defense lawyer, at some point you persuade yourself that you can actually win anything. But his client, took the deal, and part of the reason for mentioning this case is some of the lessons to be learned from it, which is that Jack did not expect that Chambers was going to end up doing what he did, which was the whole 15 years. He got all of his good time taken away from him when he was locked up. Then, also what happened is, and just following up and reading some more about this, Chambers ends up, he was certainly pursued by Jennifer Levin's family, who thought that Chambers, should have spent the rest of his life in prison. So they kept pressuring law enforcement and to keep him locked up for as long as possible. And then Chambers ended up, after getting out, he ended up in a cocaine distribution case. So now he is actually back in prison, and I don't think he's eligible to get out into something like 2024. So I don't know what the lessons are to be learned from this, except that partially, when you think you're taking the best deal, you think you're doing the right thing, but then if law enforcement really wants to continue to go after your client and pile on the years, if they get caught doing something, this is what's going to happen to them. I don't know that if Jack were alive and continued to represent Mr. Chambers, if he could have done any better than what happened, but I'm sure he would have done his best, and he would have fought for him, all along the way. That was one other thing I would say about Jack too, which is he's a very smart guy. He's a real intellectual, and I think that if you were on a jury and he was presenting the case to you, and you're wondering, like, what is really going on here? Who knows what's really happening? You would always look over to him, because he was going to be the person who was on top of every detail, well-informed, well-spoken, and a strong advocate also. I personally miss him, and of course, he has two wonderful children, one of whom was a Harvard defender, who also works in the appellate division in the public defender's office in New York, Benjamin. Sacha's not a lawyer, but also a great supporter of our organization, and we appreciate that a great deal. So one thing I would just say, I was just showing this to Sarah, which is just to talk a little bit about about Larry Krasner. So here's what you kind of get up against. There was some article in the New Yorker about Larry Krasner, and so here's somebody writes something into the New Yorker in response. Jennifer Gonnerman gives an incomplete picture of Philadelphia activist District Attorney Larry Krasner. In the past few years, Philadelphia has evolved into a progressive utopia, but homicide and poverty rates remain stubbornly high. City leaders, including Krasner, use tactics of ideological warfare to combat the decades-old problems that have plagued the city. In his zeal to combat mass incarceration and social injustice, Krasner has dismissed victims of crime and looked upon members of law enforcement and their families as ignorant and intolerant. As a lifelong Philadelphian and progressive, I am dismayed that Krasner focuses so much on the accused and so little on the victims. The streets of Philadelphia are more than just an ideological battleground. So, I'm sure Sarah will have something to say about that. But you see what? When there's an effort to try to change the system, this is the kind of pushback that you get if you're trying to be a progressive prosecutor, which Mr. Krasner has tried to do. Anyway, I look forward to hearing from our summer Litman Fellows who did some good work this summer, and enjoy the evening. Thanks.
So in years past, the Litmans have tried to be here with us to celebrate this occasion. They both have young kids this year, and so we're going to try to see if we can pull Ben up on the screen. There's a new Litman.
So he was actually around last year. Sacha's also joining.
Oh, great.
But I just wanted to, unlike last year when Jack was unable to join, this is the newest Jack Litman. This is Jack Michael Litman. So the Jack T. Litman Fellowship still lives on with a different middle initial, but Jack wanted to say hi to everyone. Okay, he's gonna go eat dinner now. I'll just speak quickly and then I'll pass it over to Sacha. So first of all, I just wanted to thank everyone for coming tonight. We can't see how many people are there, but it certainly sounds like there are a fair number, and that's wonderful for us to know. And we obviously the program is now in, I think it's 7th year, which either 6th or 7th year, which is a wonderful trajectory to date. And I want to thank especially Sam and Oliver for their initiative in coming up with the panel discussion for this year, which is something we have not done before, and certainly something my father would have welcomed. What John didn't mention is that my father, for those who don't know, actually started his career after HLS in the district attorney's office in Manhattan. So I think he in particular would have been very much taken by the topic for tonight's panel discussion, especially given what John was saying about Larry Krasner's new role in Philadelphia and what that might mean for prosecution in that city going forward. So he always thought at the time when he was getting out of law school, he knew he wanted to be a criminal defense lawyer, but there weren't many practitioner positions available at that level like there are now. So several of his professors suggested that he go into the DA's office. And knowing all along that he wanted to become a criminal defense attorney, he basically learned as much as he could while he was there and used everything that he learned to become a wonderfully successful criminal defense attorney. So there is a lot to be learned from DAs out there, especially ones who perform their duties righteously, which it sounds like Larry is trying to do in Philadelphia now. So I certainly look forward to hearing what Sarah, I believe, Sarah has to say. And Simmi, whom I got to know last year, also interested to hear what she has to say, especially because I'm currently, as she might not know, reaching out to Bronx Defenders to potentially sign on as an amicus to a Fourth Amendment standing case that I have before the New York Court of Appeals. So Simmi, we can talk about that separately offline, but I just wanted to thank you for being here as well. Obviously, Marcos, Mary, and Sam, congratulations on being Litman Fellows. We're both very proud of you and very much looking forward to hearing what you have to say about the work that you did. And then finally, just wanted to thank Sam and Oliver again for putting this all together for what promises to be another wonderful Litman Symposium.
It sounds like Sacha's stuck in a car and we may not get him. Sacha, you've muted yourself.
Well, there you go. I was saying that unfortunately can you hear me now?
Yeah.
I was saying unfortunately you're finding me in my home away from home, which is the back of a Lyft or an Uber, which is just the general nature of my work. So I wish I could show you the newest child on my end, but also named after my father, though we didn't use Jack because she's a girl. We used my dad's nickname, which was Jules, as her name. And if I could put a picture up through Zoom, I would. But unfortunately, I'm not able to parlay the technology effectively to do so. But again, I think, as you guys think within your own families about legacy and what legacy really means, as I think Benjamin and I just exemplified, obviously the most tangible part of legacy is always your progeny and the continuation of your genetic line in terms of like who you are and the ideas that you pass to your children. But part of it is also what you guys are doing here, which is the continuation of a set of ideas and a set of themes and hopefully inspiring others and the Litman Fellows and those of you in the audience this year about the power and the potential to continue to reform and improve the criminal justice system. And that is also a very, very potent part of what legacy means. And although, as John mentioned earlier, I am not in the field of criminal law. However, I work on a slightly different, from a professional services perspective in consulting and building analytical models, which would be completely irrelevant except for the fact that I've actually been building out across my firm at McKinsey work with criminal justice and working with corrections agencies to help them restructure how they handle and process those who have been detained and those who have been incarcerated in order to both reduce the likelihood of violence and reduce the likelihood of recidivism. And especially, regardless of your political position, I think the potential legislation that sits in Congress now and the other reforms that hopefully will keep percolating through the system. To Benjamin's point earlier, I think there are a lot of pathways to have impact in this field, and I hope that you will certainly explore all of them as you guys pursue your careers both at HLS and beyond. Thank you very much for having us, and congratulations to the fellows this year, and thank you for your work in continuing to honor our father's legacy, but more importantly, the ideas of really trying to advance criminal justice in this country.
Thanks, Sacha. So first up will be Marcos Caballo from Boston University Law School.
Can everybody hear me? I'm a pretty loud person without the mic, so I'll try to keep it. I'll sound like Chewbacca in here. All right, so hi guys, my name is Marcos Cabello. I was one of the Litman fellows this summer, and I think pretty much almost everybody here is a Harvard Defender, just about. So I'm going to breeze by a couple of my initial slides because everybody here will be fairly familiar with the show cause hearing, as that's what you guys are have been working on at Defenders. Everybody here has been pretty funny, but I didn't come up with any jokes today, so just bear with me until the end of this presentation. So today I'm going to be talking about the show cause hearing, and in particular, I'm going to be arguing that the show cause hearing should be used as an alternative to prosecution, so to speak. And as will explain in more detail, the clerk magistrates who conduct these hearings should reinterpret the show cause hearing in a way that makes the hearing more than just an administrative step in Massachusetts criminal procedure. So breezing through this here, the relevant source of law is Massachusetts General Laws, Chapter 218, Section 35A, and this is going to be a criminal hearing in front of a clerk magistrate. And so under this law, a police officer must, for most misdemeanors, first ask the court to notify the defendant before a criminal complaint is filed against the defendant, and they may also do this the officer may also do this in his or her discretion for felony complaints as well. The parties present at the hearing are going to be the defendant, the police officer, the clerk magistrate, or the assistant clerk magistrate, and sometimes the victim, as you guys know. The legal standard here is probable cause. Essentially, this is going to be just some sort of concrete fact that the officer presents to the clerk, suggesting evidence of potential guilt. And as I quickly learned here over the summer, quite literally anything could mean a piece of evidence sufficient to constitute that. I mean, we had cases where the police officers say, we have surveillance of the defendant here today doing this, without the clerk magistrate ever seeing the evidence or being able to corroborate whether it even looks like our client. And so the show cause hearing at times felt like the clerk magistrates had their minds made up, but I think that if they redefine what the show cause hearing is to look like, we can really start helping aid some of the criminal justice issues we have in the United States, which leads me over to talk a little bit about mass incarceration and the parole probation scheme. So currently we have 2.3 million people who are incarcerated in correctional facilities, and almost more than twice that are part of probation and parole. So that's 840,000 people on parole and 3.7 million people on probation. And originally when this was founded, this was thought to be an alternative to prosecution, but unfortunately it has skyrocketed in numbers to being something much bigger and honestly a little bit more harmful than the original founders intended it to be. And just here in Massachusetts, being on probation, for example, is prohibitively expensive. The administrative tier is $50 per month, and the supervised tier of probation is $65 per month. And we've had research that shows that this has a discriminatory impact because probation rates are highest in the poorest communities and they are lowest in the wealthiest communities. So the question is, how can we start to aid some of these problems? And now, kind of to run this point home, I just want to quickly tell the story of this woman, Danielle Hall, who she was written about in the New York Times. And essentially, she had a really weird condition on her probation by the judge, which said that she couldn't move in the time while she was on probation. But she developed a mouse infestation in her apartment, so she wrote to the judge on August 19th and said, I'm going to be moving, here's my new address, and it's just a new unit right around the corner. On September 19th, an officer showed up with a summons, and so she had to go to the court to explain this move. But the kicker is that she actually never got to move because the apartment wasn't ready. Nonetheless, she got the summons, and it took 3.5 months, 5 court hearings, 3 letters from the landlord, and a copy of the lease just to move from one apartment unit to the other. So what can we do in these show cause hearings, and what can the clerk magistrates do? I think that the clerk magistrates should reform their way of thinking of the show cause hearing and should construe the hearing in a way in which the goal of the hearing is to take care of this criminal matter without further court action. And so in a way that starts looking like an alternative to prosecution, so to speak. And this should be their goal most of the time. It definitely should not be the goal all of the time, because for some offenders that come into the system, such as, and Mary's going to be speaking a little bit about what it looks like for mental health defendants, they might want them to get the court resources for mental health. So not in all cases, but the argument here is in most cases. So I've written up a list of a couple of things that the clerk magistrates could do, just general formulas, but this isn't exhaustive. This is just an illustrative list of what they could be doing at these hearings. So the first is criminal mediation. This is going to be a situation where here the goal is to bring criminal disputes to a resolve, and all key parties should be present. The police, the defendant, ideally with his or her counsel, the clerk magistrate or their assistants. And here I've emphasized victim with advocate. The United States in the criminal justice system has left out the victims for a good portion. They have neglected the victims in the system. And so I think having an advocate on staff that could go with the victim and talk about what their rights might be and what sort of restitution payments they might be able to ask for. And so that brings me over here to the next point. Normally these criminal mediations are going to end on a restitution payment. And this is not going to be appropriate for every single defendant that comes through. At Harvard Defenders, we represent indigent clients, so for them, any amount of restitution might be a lot, but there are some offenders that might come who may be able to afford those restitution payments. And as I've written down here, it fits under our general conceptions of justice and personal responsibility, because the defendant pays for the harm that they've committed. The victim recovers on their losses, but that defendant gets to move forward with their lives instead of continuing with that costly probation scheme or parole and incarceration thereafter if they go to trial. The second thing that they could do is enact certain compulsory measures. And so here, this is just a list that I compiled from the Criminal Code of Lithuania. These come from Article 67. But just going through them, the first one, banning to use a special right, community work, payments to the state fund of the victims of crimes, which I'll come back to in just a second, property confiscation, prohibition to approach the injured person, participation in violent behavior modification programs. So the reason that in particular, the third one here, payments to the state fund of the victims of crimes, again, this engages victims in a way that they've been largely neglected in the United States, but also I want to highlight here the West German day fine system, where they don't use a fixed sum for any amount of fine or restitution payments. This is actually, for them, a variable figure, which is adjusted to the wealth and income of the offender, which makes sense because a fixed fine could impose economic hardship, severe economic hardship, on a poor offender but cause nothing more than a mere reduction in consumption for the offender of means. And so this variable fine is designed to have a proportionate impact across economic strata. And lastly, I think this is one to really emphasize here, discretion to dismiss. And the clerk magistrates do have this discretion, particularly Article 212 of the new criminal procedure of Lithuania actually outlines some circumstances where judges could dismiss the cases that are in front of them. And two in particular that I thought were really interesting. The first one is that they can dismiss a case when it is recognized that a certain person or the offense has become not dangerous because of the change of circumstances. So Here, this last question, what aspect in our justice system changes significantly with this framework? Well, in the United States, we have this idea that those who are being tried for some crime should be found guilty and punished to the outer limits of the law, but that doesn't really make any sense if there's a change in circumstances, if the offender is no longer dangerous, and the whole matter could just be disposed of with the discretion of the clerk magistrates. The second one here, and this kind of goes back to criminal mediation, is if the suspect and the victim are reconciled, and Sam's going to be talking a little bit about that during his presentation. But again, it doesn't make sense to bring criminal action on an offender when the two parties have reconciled. With their, and Sam in particular is going to be talking about families, and this actually has been brought up before, where either a mother or a daughter will be brought because they've had some dispute and some criminal offense will be brought against them, and really this should be dismissed. And now the Constitutional Court, I'm sure you guys all studied the hand formula in torts, unfortunately. The Constitutional Court there, in one of their cases, held that they outlined a general formula that legislators could take into account when drafting legislation in regards to discretionary measures that may be taken by any of the judges. So they can take into account the criminal deeds, the danger, the gravity, the scale, and then other important aspects or circumstances that are attached to this offense. So with that, I do want to point out that with this framework comes one conceptual trap within the show cause hearings, and that is that if a clerk magistrate orders a defendant to pay restitution, that is a little bit in conflict with the presupposition of innocent until proven guilty, because you start asking yourself the question, well, if the defendant's paying the restitution, that means they're guilty, right? And I think that the way to fix this problem here is to guarantee that the defendant's going to know of their right to proceed forward and claim their innocence and speak with the prosecutor, or to then go to trial and continue to claim their innocence there. And this way, this is going to avoid an issue here where the defendant's going to think they just have to do it without giving them the choice. In a way, this starts looking a little bit like a plea deal, which is essentially what happens in plea deals. Sometimes the defendants in plea deals may not actually be guilty, but they think for the purposes of their trial, it's the better option of the two. But I think more importantly, the Constitutional Court of Lithuania also emphasized that the categorization of guilt should be specially reserved for when the crime is proven through criminal procedure and the defendant is recognized guilty by an effective court judgment. So we should withhold any sort of talk about this offender was guilty simply because they were paid restitution, and only be using that word, that vocabulary, when appropriate and the offender has gone through the proper trial, and again, that effective court judgment has been passed down against them. So in conclusion, and an important footnote to this entire presentation, is that this is just a short-term solution to mass incarceration, parole, and probation rates. Really, the long-term solution is going to be formalized legislation that reforms our court system and actually gives some of the judges the abilities to dismiss these cases and reforms it up there at a higher tier of the system. So before I turn it over, I want to thank you guys for coming today. I look forward to hearing your questions, and I'm excited to be eating some food with you guys after this. All right. So does anybody have any questions? Yeah.
Just curious.
No. Yeah. There you go.
Just curious. Why Lithuania?
To be honest with you, I was doing research, and they, out of what I could tell, they had this stuff formulated and outlined, not only by the Constitutional Court, having had some opinions on this, but also through their formalized legislation in a way that I didn't really find anywhere else. I looked at China a little bit, and honestly, they have this idea, while in spirit is good, that they should try not to bring everything to court, basically to mediate things outside of court. It could be a little bit oppressive in practice in the way that they've done it in the past. So I think Lithuania, to be honest with you, in practice, I'm not sure how well it's succeeded, and their culture is going to definitely impact what that system looks like. But they just had this stuff outlined so well in their criminal procedure that I felt that it was a good kind of indicator of what we might be able to do. Yeah. Okay, well, if there aren't any other questions, I'll pass it over to Mary.
And I'll just introduce Mary quickly. Mary is from BC Law, and we'll be talking about mental health in the courts.
Hi, everyone. Is this on? Yes. Okay. I'm Mary, and I was fortunate enough to work for Harvard Defenders this summer, and I loved it. It was a great experience. But I do want to tell you a quick story about one of my clients over the summer. So I actually worked on 2 of her cases throughout the summer, once in June, once in July. And throughout her cases, she unfortunately had pretty severe untreated mental health conditions. So initially, when her offenses had occurred, she had no kind of diagnosis despite many visits to different doctors. She had pretty severe symptoms. She was carrying a knife with her at all times because she was so afraid that others were out to get her. Her different cases were very similar. They both had assault with a dangerous weapon. Both of them had multiple felonies that were alleged. And unfortunately, they came out very differently over the course of the summer. So at her first case, the clerk decided to dismiss it outright. The clerk actually focused on how my client was already seeking treatment. She was doing everything that she could to try to improve her mental health and trying to take care of that so that she wasn't a recidivist. He emphasized that he wanted her to continue that treatment. He didn't want to interrupt, and by issuing a complaint, he would be interrupting that process. At the second case, though, the clerk approached it very differently, and these were 2 different clerks as well. But the second clerk decided that her crime was too severe to not issue the complaint. So he ended up issuing it outright with no kind of consideration for her mental health. He thought that the public safety concern by far was more important in outweighing her exposure to the public, and so he needed her to have this complaint issue for that reason. In doing so, however, he emphasized that she should seek the mental health courts, and he wanted her to gain access to that. So from there, that obviously spurs a discussion about what the mental health courts are and how that is being treated. These mental health courts are a specialty court. They are designed to take mentally ill defendants out of the traditional criminal justice system and put them in a specialty treatment program. These programs are mandated by the court, so any defendants who actually enroll in the mental health court must comply with the terms of the treatment. In 1997, there were 4, now there's over 300. This is great. This is obviously a pretty big expansion, but it's not big enough. And what's being done isn't good enough. There are some really great goals, increasing the public safety, trying to make sure that defendants are actually getting treatment for conditions that they need treatment for, trying to improve their quality of life by getting them access to that treatment, and then lowering the costs for the courts. It's much cheaper in the long run to make sure these defendants have access to mental health than to have them keep being recidivists, entering the criminal justice system, and potentially being incarcerated multiple times. So that all helps to promote greater justice. That helps to ensure that these defendants are actually getting the help that they need so that their underlying criminal behavior stops happening. Unfortunately, a lot of the time, as was with my client, her mental health condition is what spurred her criminal conduct. If she had adequate mental health treatment, that would all go away. And so by having these mental health courts, we're promoting that behavior. So in theory, this sounds great, but in reality, it's not. A lot of the time, mental health courts are very arbitrary and discretionary at multiple stages. So the mental health courts have 3 different screening stages that ultimately will either allow the defendant to enter the court or keep them out of the court. So we'll talk about all 3 and the problems associated with each stage. So at the first stage, the initial screening, basically a referral source will recommend that a defendant enter the program. And so they'll consider a bunch of different factors, including their criminal charges, their mental health status, and a filtering agent will ultimately review that, the filtering agent being the district attorney or the mental health professional. Unfortunately, the problem with that is that the referral source will influence who is actually accepted or denied, and this can happen through a reputation. So defense attorneys are most often the ones who will actually make that referral. And so sometimes their recommendations go unseen or unreviewed. But whereas if a clerk is to make that recommendation, sometimes that weighs more heavily because that's not done that often. But in addition, filtering agents will sometimes bypass any guidelines for who to accept or who to deny. Sometimes they're described as buy-ins. So if there is a good incentive or a personal favor that can be done, sometimes the filtering agents will completely bypass that and make a very subjective determination depending on what they ultimately want. And then there's no check and balance on the system. In some courts, the mental health professional will unilaterally decide what to do and no one will review it. And this calls into question whose expertise is actually making this decision and is that appropriate? At stage 2, the assessment screening, the filtering agents will assess 3 different factors: treatability, suitability, and risk of violence. And they will make a determination based off of those factors whether they should move on to step 3. Some of that depends on if they think that someone will actually comply with the treatment program. However, that's problematic within itself because they have mitigating factors that they examine. And those factors include if the connection between the mental illness and criminality is weak. Well, that's great, but what's weak? Why is there no definition for that? Same with it being too prone to violence. What is too prone or not prone enough? And a client whose behavior does not fit the culture of the court, well, what's the culture? Why don't we have a description of that so we know who actually belongs? And then, of course, again, at stage 2, there's still not really a check and balance, but there is some effort at this point. The defense attorney, the prosecutor, or the judge here can actually outright reject the mental health professional's recommendation. And this is problematic because that calls into question the expertise yet again. So if a mental health professional is making a recommendation, they should know best whose mental health status is worthy enough of being in this program and needing that treatment the most. At stage 3, if someone is lucky enough to get there, the court will actually extend the offer of participation, but the defendant does not have to accept. They can accept or reject those conditions, and if they end up rejecting, they'll end up in the traditional criminal justice system instead. Now, this stage doesn't seem quite so bad as compared to the other 2, but again, here we have unchecked discretion. The judges here sometimes are permitted to meet with defendants one-on-one in their chambers before making a determination as to whether a defendant should be admitted, which calls into question what kind of factors the judges are looking for and why isn't every defendant getting that same kind of treatment. If the judge has a personal bias against someone, a selective bias, that could ultimately influence who is being accepted or denied. And then once that judge makes a determination, there's no one left to review it. The judge has the ultimate say at stage 3, and that's how it's left. Additionally, defendants here can be coerced into making a decision about entering the program. There's a lack of meaningful choice. You either go to jail or you go to a program that you don't really want to participate in. For a lot of these defendants, it's not a clear-cut choice, and so those factors are definitely being considered at stage 3. So what does that mean for my client? Well, at stage 1, the clerk's recommendation could go a long way. As I had mentioned, clerks don't usually make these kind of referrals, and so having a clerk's referral could mean that it'll be given more weight. However, if the clerk makes this recommendation, who's to say that the filtering agent will actually approve it? Yet again, the filtering agent can make that subjective determination to bend the rules or to keep someone out prematurely. At stage 2, yet again, she could be denied because at stage 2, we have those mitigating factors. We don't know what those really entail. There is no definition for that culture or too prone to violence or that connection. So at stage 2, it depends on who actually reviews the case. It's luck of the draw. And then at stage 3, if she gets that far, she could still opt not to join the program based off of a buy-in or based off of an incentive where she has no real choice. So really, her future is completely uncertain and there's no saying. Obviously, in theory, the mental health courts sound great, but in reality, there's a lot of room for improvement, and that begins with defining very objective criteria for the judges, clerks, prosecutors, defense attorneys to consider in these decisions. questions? Yes.
What does the advocacy look like in these courts on behalf of the defendants? Is it kind of arbitrary, just kind of trying to make it happen, or is there's not really very good criteria? So what do lawyers do?
So at these, it depends on the jurisdiction. So I'm not sure specifically about Massachusetts. Unfortunately, the downfall of this research is that there's just not a lot about it. But depending on the jurisdiction, some mentally ill defendants who are trying to go through this process will be allowed to have a defense attorney with them. Not all the time. So that's also part of the problem, right? Because if some defendants are able to have their attorney with them to guide them and try to advise them, they might be more likely to get that entrance if that's what they're seeking. At every stage, though, no matter the jurisdiction, at stage 3, you will absolutely get counsel, and that your counsel should be advising you about whether it's more beneficial for you to enter the court or not. But again, at the other 2 stages, there's not really any set guideline, unfortunately. Other questions? Yeah.
In the course of your research, have you seen whether or not judges or medical health professionals or DAs, they have discretion to prescribe a certain course of treatment or recommend a certain course of treatment? If so, what does that look like? How does that play out?
Yes. So they are allowed to subscribe different forms of treatment. Every defendant's conditions to enter the mental health court could slightly vary. Generally speaking, the most common treatment that I have found, at least, is that the court will mandate they go to a treatment center, have therapy at least once a week, and they'll have basically meetings every so often, usually about a month apart, I believe, with a probation officer, just to make sure that they are actually complying with the treatment. I don't know if there's random checks in the meantime to make sure that they are going, but I imagine that there probably are. Other questions? Okay, thank you.
Last up is Sam Faisal from Suffolk Law School to talk about family mediation in the criminal courts.
How's everyone doing tonight? Can you guys hear me? All right. So family mediation in criminal courts, first off, I want to start off by saying, what is family mediation? Family mediation is pretty much mediation that promotes the discussion and negotiation that allows the participants the opportunity to exchange their views, questions, and just discuss between the 2 parties about the issues that they have before each other. Family mediation is there to foster an amicable solution between the 2 parties, whether or not it be a mother and a daughter, a brother and a sister, whatever it is. If it's within the family, it's there to help them come up with a solution and keep it in the family. With family mediation, it's obviously between a mother and a daughter or between the family members, with mediator in between. The mediator's role is there to serve as a detached and neutral third party who assists in promoting that discussion and helps to find a solution that would work. And in Massachusetts, a mediator has to satisfy these requirements. They need to complete 30 hours of training. They need to have either 4 years of experience as a mediator or be held accountable to a dispute resolution organization or be appointed a mediator by a judicial or governmental body. So how family mediation is used today is, as well as these 3, it's used in several different aspects in the law. It's used in divorce proceedings where it's helping divorcing couples to avoid litigation and the hostilities that accompany the litigation. And it helps them come up with a satisfactory agreement so that they may finalize their divorce and just, be on their way. For custody hearings, unfortunately, fortunately, it allows the parents to come up with a solution so that they can figure out how to divide their time with their children. It allows them to figure it out one-on-one with the help of a mediator so that a judge isn't the one that's coming up with that decision for them. In the housing courts, or mostly in housing courts, it's for all types of mediation, not just family mediation. So there are housing specialists that give the party the opportunities to resolve the disputes that lead to the evictions or just between their roommates. So this can happen again with families if a brother and a sister are living together, or a mom and her son, or whatever the situation is. In the criminal courts, mediation isn't really used too much. However, there are two distinct ways that mediation is used in the criminal courts. The first off is the victim offender mediation, which typically occurs after a conviction. How the victim offender mediation works is that it allows, after someone's been convicted of a crime, it allows that offender to meet with the victim so that they can come up with a solution that may reduce the sentence of the offender. And the alternate dispute resolution occurs somewhere in between the charge and the actual verdict of the trial. It allows, again, the victim and the defendant to come together to talk about an amicable solution that they can figure out so that this offender or the defendant isn't completely charged with the crime. I'm not sure. So both of these forms of mediations are very satisfactory to both the victim and the offender. There's over an 80 to a 90% satisfactory rate that has been shown, and it offers the party time to resolve the conflict and to construct their own solution to these to the issues that they're facing. So my proposal, after working with the Harvard Defenders, is to implement family mediation prior to the show cause hearing. So everyone knows that the show cause hearing is usually the initial first step after someone is issued a criminal complaint, or they have an application for a criminal complaint filed against them. I'm saying before that they go before a clerk magistrate, that they have the opportunity to see a mediator so that they can talk about their issues between their family members. If a mother and a daughter, like a case I had over this summer, have a dispute, they should have the opportunity before the mother has a criminal charge pressed against her to talk with her daughter in front of a mediator to come up with an amicable solution so that it doesn't potentially ruin the mother's life. So family mediation before a criminal show cause hearing may reduce the probability of the criminal charges being pressed. It would provide the opportunity to speak with the family members before a qualified professional, and it would provide them with the ability to come to an agreeable solution. So with mediation, there are plenty of benefits and there are a lot of pitfalls as well. So mediation in the past has shown an 85% success rate. And some of these benefits include the voluntariness of mediation, time and cost efficiency, confidentiality, durability, and cooperation finality. Essentially, with mediation, with a mediator, everything is confidential in that mediation. It cannot be used, what is discussed in that mediation, further on if the case were to go on. And mediation is completely voluntary. If one party doesn't want to participate, it won't work. However, some of the pitfalls of mediation is that the parties not attending, 25% of all mediations fail because a party doesn't want to participate. 24% of mediations fail because the parties lack the resource for the mediation, meaning that they don't know what they want to get out of the mediation. And that's the same with the lack of preparation for the parties. 21% of mediations fail because of that, and 21% fail because you show up and your partner is very hostile. It can happen with a divorce proceeding, you know, people don't like each other anymore. Where are you going to? So these are the 3 prior cases that I handled. All the names have been changed. So essentially the first one, like I was talking about earlier, Jane Doe and her sister got into a verbal argument during their mother's birthday party. Jane Doe's sister followed her out of the building. When she opened the door, her sister was claiming that she got hit with the door, called the police, and she had felony charges pressed against her. The second case, John Smith and his girlfriend, they were partners for over 20 years, and Emily, his girlfriend, alleged that John had stolen $20,000 out of an envelope from her apartment. Yeah, really weird. The third one was the one that I talked about earlier, where it was a mom and her daughter, where her daughter Alexa, who was only 15 years old, came home with hickeys on her neck and body against the house rules. And mom got mad and gave the daughter a good hit. And the daughter was fuming about being hit, so she went to the police station the following morning and filed a complaint with the police. So implementing family mediation in these three cases, by the way, the first case with the mother was dismissed because the sister didn't show up. But the other two, the one with the girlfriend, was continued for a year, and there was a restraining order against John with his girlfriend for that entire period as well. For a relationship that was going on for over 20 years, for a simple dispute that could have been solved with a mediator, by talking it out and figuring out what actually happened to the $20,000, because I'm sure they're both wondering about it. I know I was. So that complaint was continued for a year, and they had a restraining order where John couldn't talk to his girlfriend for that entire time. And the third one was continued for 6 months as well. So different outcomes with the family mediation. Jane Doe and her sister, thankfully that was dismissed. However, that could have been a felony charge, a felony assault and battery on Jane Doe for a simple miscommunication that had occurred at the mother's birthday party. Were they given the chance to talk in front of a mediator, they could have figured out some of the kind of disagreements that they had on that day and days past. And talking it over would have just squashed the entire issue. It's the same with John Smith and his girlfriend. They could have talked for a little bit. They were partners for over 20 years. By the way, John Smith was like 80 years old at the time. He could have talked with his girlfriend and figured it out. Since they didn't live together, however, they lived very close in proximity to each other. Having the restraining order on John Smith would have caused great difficulty for John to figure out how he was going about his daily life. Sarah Brown and her 15-year-old daughter. For the entire time that between figuring out and going to the clerk magistrate's hearing, her 15-year-old daughter was living with her grandma. Now, this separated a mother from her daughter because of an issue that her daughter was in a heat of passion and went to the police station and tried to figure something out. She wanted to get some revenge on her mother. Having the chance to talk with her 15-year-old daughter in front of a mediator to figure out what were some of the underlying issues and figuring out what can we do in this household to make our lives better. Rather than going about and going right to a clerk magistrate, having the possibility of having criminal charges pressed on her mother and going and having the attorney costs for trial and all of that, it could have been solved right before a clerk magistrate's hearing and could have been squashed right then and there. So, any questions? Thank you. Well, for Jane Doe and her sister, for the entire time, they were not on speaking terms at all. And it was unfortunate because her sister had a son that Jane Doe was kind of babysitting all the time, and they just didn't want to talk to each other because of this one incident. However, if they were provided the opportunity to go in front of a mediator, kind of like a counselor, and talk about what were some of the issues that caused this, I feel like they both would have been open to that, to solve that underlying issue within their family. Did I answer? What was the second part of your question?
Yeah, it was more like hypothetical, just like if you wanted to act on this, maybe too practical.
So, okay. Well, I know in some of the, like in civil trials, people would go before a judge, and the judge would offer, say, do you guys want to try and solve this in mediation before we actually continue on with the trial? With this implementation, it would kind of work the same way, where both parties would have to show up to the courthouse, which is probably the hardest thing to do. Have both parties show up to the courthouse, and before they go in front of a clerk magistrate, have them talk before a mediator, or have the clerk magistrate offer to have them go speak with a mediator before this is actually like decided, before they make a decision.
So we're talking about an 85% success rate. Does that mean that 85% of cases, like 85% of cases were resolved without having to go to court? What is a success?
Yeah, so, well, with mediation in general, the success rate is kind of that they aren't going to court and that they're resolving the issue right then and there. But it's also the fact that both parties are satisfied with the mediation and what the outcome was. Going once, going twice, and so.
Thank you. And now that I have a captive audience, we're going to talk about socialism for another hour. Just kidding. So next we have our exciting panel discussion. I'm going to introduce our first panelist, Simmi. There's no order, so equally first panelist. And then Oliver's going to go ahead and give you an introduction of Sarah. And you guys can start making your way up here to your respective locations. So Simmi joined the Harvard Defenders as a staff attorney in September of 2017. Yeah, oh sorry, Bronx Defenders, that's a lie, sorry. Thanks. Before that, Simmi graced us with her presence as the president of Harvard Defenders and graduated in the class of 2017. While she was here, Simmi was no stranger to activism, calling out the trash bureaucracy and oppressive practices of the school as part of the Reclaim movement, a student attorney at the Harvard Legal Aid Bureau, and as a Harvard Defender, of course. And during her law school summers, she worked on criminal and racial injustice issues with the New York City Civil Liberties Union, Equal Justice Under the Law, and Arch City Defenders. She is from India, and that's via Queens, New York. And she's at Harvard. She was at Harvard via Hunter College, represent the best college in the world. Not that I'm biased.
We'll talk about that later.
And Sarah Boyette graduated. There'll be a lot of room for applause. But Sarah Boyette graduated cum laude from Harvard Law School, where she served on the Harvard Journal of Law and Gender, worked with Harvard Defenders, and participated in CJI. She served as a federal law clerk in Nashville, Tennessee, before joining Brooklyn Defender Services as a public defender in 2011. And after almost 5 years in Kings County representing indigent defendants on both misdemeanor and felony cases, Sarah moved back to Philadelphia, her hometown. She subsequently completed her second federal clerkship and, after Krasner's election, joined the Conviction Integrity Unit of the Philadelphia District Attorney's Office, a special division that reviews convicted offenders' legitimate claims of innocence and wrongful conviction, and makes broader recommendations about the ways that the office can operate more efficiently and effectively. So, welcome, Sarah.
Thank you.
And we want to get into substantive stuff really quickly, but it would be helpful, I think, if you could each tell us a little bit about your career path and how it is that you came to serve in your current roles. So, Simmi, would you like to start?
Sure. So hi, everyone. Thank you so much for having me. I've been a public defender for a whopping 1 year and 3 months, so typical HLS style, that makes me an expert. But I am still learning, and I'm here to share insights. Of course, everything I say is not the official Bronx Defenders policy on anything. It's just me ranting. So I guess a few things that shaped my career path and my experience here at HLS would be, one, I was born in India. I immigrated here with my family when I was 5 years old. I think being around folks that were undocumented and of varying immigration statuses kind of always put us out on the margin of the systems that existed, and we kind of had to just like create our own. Police was like never an option, for any conflicts. We didn't call 911 because the risks were so high, and I think that always just kind of had me thinking about the margins, and that kind of was my intro. I was also a first-generation college student, and that really shaped my, that really shaped, I think, my experience here, and I'm also a Libra. That is probably the most central. But all that to say that I don't really have a lot of answers. You'll hear a lot of just more questions, but I'm trying to find a balance as I do this work, and I hope that I keep learning and find that.
I am from Philadelphia. I used to introduce myself as a local girl made good, but it turns out that where I'm from in Philadelphia, it turns out is the Staten Island of Philadelphia. So that's a lot. That's literally this year I found that out. I was like, oh no, it totally is. But so I'm from Philadelphia, lifelong Philadelphian, and I sort of was always inclined towards social justice, I think is the term that we use now. In a broad sense, but I didn't really know what I wanted to do when I came to law school. I think part of what sent me to law school, at least in retrospect, was the innocence movement. I've always been sort of, when it first started, it was like, the ghost of the innocent man convicted doesn't need to be worried about, said Learned Hand or Joseph Story or somebody, and it's like, oh no, I have such bad news for everyone. So I was always sort of interested in innocence work, and then I got here and I figured I would never, ever get to innocence work. And what I found instead was that I could get equally fired up about everybody, every criminal defendant that I could find. And that continued to be true and continues to be true. And so that's what sort of took me in a very, very quickly in the public defender direction. That was pretty much my focus from my first summer on. I spent my second summer at the San Francisco Public Defender under Jeff Adachi, and it was awesome. And after that, I sort of ended up clerking because I don't know if any of you guys remember, but the entire financial market and country collapsed while I was in law school. And so I ended up clerking because I got a clerkship earliest in 3L year. And so I was like, great, I can just put a pin in it and come back next year. So after my clerkship, I ended up at Brooklyn Defenders, and I was there for 5 years. Talk to me after. It was a great place to work. I was a little spoiled because Brooklyn is a very defendant-friendly jurisdiction. And so my idea of a win was complete dismissal, a dismissal and an apology preferably. But so that was my idea of a win, and I got very put out when that wasn't what I would get. But we got it a lot. So it was a wonderful place to work in that sense, but it was also a little bit like Candyland, which is also true of San Francisco, in case anyone is wondering. But then I moved back to Philadelphia. I had my daughter, and you run out of money in New York eventually, FYI. I've been on LIP for 8 years.
Yeah, let's talk about LIP. Let's make this a panel about LIP. Yeah.
After. I moved back to Philadelphia. I ended up in another clerkship sort of randomly. I liked it a lot better that time because I had sort of gotten my courtroom yayas out, and I was happy to just sit in a room and produce something sort of more polished. Like written work as a public defender is like, oh my God, I have to write a motion on like how disgusting an apartment has to be before it's endangering the welfare of a child. And it's like Westlaw searching for excrement, like Westlaw searching for like insects on bed, insects within sentence of bed. Yeah, there's a lot. It's always interesting. But so I moved back to Philadelphia, my clerkship ended, and I was just sort of looking around for the next thing. I was still on LIP, so I needed something LIP eligible. Welcome, friends. And Krasner got elected in the middle of all that. And so I'm like reading, I'm like on my phone, like on my couch, reading aloud, like Larry Krasner's interviews. I know he's been here. I don't know how many of you guys came to see him. I'm like reading aloud his interview, and I'm like, oh my God, this is amazing. It's like the inmates are running the asylum in a good way. Again, sorry, preface, also don't speak for Larry Krasner, just myself. Great. My husband's like, you should totally just send him an email. You'll totally get a job with Larry Krasner. I was like, I don't know if I could be a DA. And it's a real head trip. But so Larry he's like every bullshit session that every public defender has ever had at a happy hour, like with power. It's like, oh, you're gonna make DAs stand up in court and justify a term of incarceration in terms of how much it actually costs, instead of like these abstract numbers like 30 days or 1 year. Like, it's like, no, that's a real amount of time. Like, that's a real amount of time to put somebody in a cage and like think about it. Think about how much you didn't like being grounded for a week, right? Like, times a bajillion. So I'm like reading all this stuff about Larry Krasner. My husband's like, you should definitely apply. So I sent his transition website, this is after he got elected, a very colloquial cover letter. And then several months later, I was still looking for work because, welcome friends, you will also still have to look for work. The degree does not get you everything you want and more. So I came in and I met with Larry, and I told my husband after, I was like, it's like Bizarro Roy Cohn. If any of you know who Roy Cohn, okay, no. All right, that's fine. Like intensely charismatic, very funny, very wry, and just like a profound source for good and like realism in the criminal justice system, and no posturing, and whatever he says he's gonna do, he just does it. And everything he wants to do is like good for the world. It's bananas. So that has definitely helped me overcome my reticence about working as a DA. Although like Patricia Cummings, who's my immediate supervisor at the Conviction Integrity Unit, she's like introducing me around on my first day. She's like, this is our new prosecutor. And I'm like, can we just like call me something else? So I am technically now an ADA, and it's weird. But I keep up like an email thread with my old colleagues from BDS, and I'm like, send me your craziest ideas and I'll run them by Larry. So we're working on all sorts of things. Technically it should be innocence stuff mostly, or wrongful convictions, and then sentencing injustice. But basically it seems like anytime Larry has like something going on that he thinks like implicates old cases, he just sends it our way. So we're working on like sentence commutations and clemency applications, like habeas. It's like anything you can think of. So I am an ADA, but I work in the Conviction Integrity Unit, and they think that we're all like rats and snakes, so it's fine. At the office, it's been fun. I think Larry Krasner's great, and I will sing his praises to anyone, even though I have met him twice. Okay.
So thanks so much. I don't know if you guys can hear me, hopefully. Thanks so much, Simmi and Sarah, for those introductions. And obviously a lot of topics that we can now talk about during this happy hour: how to live cheaply in New York, how to search on Westlaw, which I don't think I'll ever know how to do. But jumping right into the questions, like any good panelist, I will use a quote from somebody else to begin our panel questions. So Michelle Alexander, in The New Jim Crow, she wrote, "The fate of millions, indeed the future of the Black community itself, may depend on the willingness of those who care about racial justice to re-examine their basic assumptions about the role of the criminal justice system in our society." And what assumptions do your organization challenge in relation to the criminal legal system in your work day to day, and what limitations are there? And maybe we'll start
Sure.
with Sarah.
Yeah. So it's really interesting. I saw the quote and I was like, I'm sorry, I have not yet read The New Jim Crow, but Larry has, and he makes all the newbies read it, and it's going to happen in due time. But so I like looked this up, and what I understand Michelle Alexander to be saying is that the criminal justice system, despite the fact that it appears that you can avoid it because it's voluntary, theoretically, whether or not you commit a crime, that's just so much window dressing, right? And that, you know, if we're honest with ourselves, everybody makes mistakes. Everybody makes mistakes of a criminal dimension, and only some people get caught up in the criminal justice system. So, you know, the criminal justice system as it is today, certainly at the DA's office, they say things like, we're just here to look out for public safety, right? That's what we're about. We're about making sure that the public is safe. And so, I haven't read it, and I apologize. Totally on me. But so I was thinking about it, and I was like, okay, so that sounds like Jim Crow is just like, you know, oh, we're not like, you know, we're not engaged in maintaining the primary vehicle of racialized social control. We're just like in the business of like accommodating people's social preferences. And like the, you know, people who were promoting and involved in slavery, there's like, oh, we're not engaged in, you know, the mechanism of the primary vehicle of racialized social control. We're just like doing the labor market. So, right, that's like a big deal to me, because I think we can all agree that safety is good and that hurting people is not good, and we should try and avoid it. That's my jumping off point. I don't like it when I get hurt. I don't like it when anybody else gets hurt. I would like for the people that hurt people to stop hurting people. At the same time, though, it has to stop being the primary vehicle of racialized social control, which of course it is. So the question is how you pursue that utilitarian goal of making sure or trying to help people not hurt other people without perpetuating this country's spectacular legacy of racism and marginalization. So I guess Larry's answer is tear it all down. But I don't have a great answer. I think the answer is to try and radically rethink all of it. Try and radically rethink every tenet that you have ever relied on, and try and be really evidence-based. I feel like the social sciences have a lot to offer us in terms of like criminology, like what are actual recidivism factors, what are actual risk assessments, what do those look like, and can we move forward based on those instead of like relying on lay intuitions about, you know, oh, he's gonna recidivate, or like, oh, this person's too prone to violence, right? Like, what is that based on? Like, please give me a citation. Like, you know, somebody has done this research, surely you can look it up. So I think in my office, at least, that's the hope, is that it can be a really evidence-based thing because people are doing good work on this subject, and we can't really, it seems like a good jumping off point, at least, to try and be really rigorous about best practices and things like that. That's my long-winded answer. I'll turn it over to Simmi now.
So once I left the law school bubble, I realized that people get like very upset that I'm a public defender. I've had like a woman at the gym just be like, your parents must be heartbroken that you do this. It's like, no, they're not, but thank you for your concern. And I think the one thing that will like get me by sometimes is like, well, you know, everyone deserves a defense, and you know, it's in the Constitution, and it's good work because everyone deserves a defense, and this like objective defendant that deserves a defense. And I think the Bronx Defenders has made a lot of attempts to like challenge that, and to state very openly that's not why I do this work. I don't do this work because there is this objective, neutral right to everyone having a defense. I do this work because there's a racist, classist system that we must challenge. And it's not that I would represent, you know, any person of any means. White collar defense is not the same as my work to me, because there are different political goals. And I think in my tenure so far, I have found us having those conversations, and that has been really meaningful and important to sustainability. So I think there's a lot of potential answers, but I'll keep it to that. You also asked about limitations, and I think, so my class at Bronx Defenders was the most racially, ethnically diverse class they've ever had. Prior to our year, it was a very white institution. In our year, it was a lot of folks, black and brown people, a lot of folks from New York, from the Bronx, first generation college students, which is all amazing. But I think we're still learning about how race truly shapes like every interaction you have in this system, right? And like most of y'all know this. But I think, you know, our interactions with judges, with prosecutors, with court officers, with clients, we get worse offers on things. And we're just starting to learn about that. And I think to some degree, public defense requires buy-in into the system, which I like knew in an abstract way, but I think I realized for real when I started doing this work. And it was that, you know, naturally courts expect us to give them legitimacy and to believe in this process that's been set up. And I think for folks that have been affected by it, that come from communities affected by it, it's harder to do that. There's more of a dissonance, and I think that makes it really hard. So I think sustainability is a question that we think about a lot. My team has been thinking about a lot. And sustainability for Black and brown people that come from affected communities who want to do this work.
I want to just really quickly, the assumption that gets challenged specifically in what I do is that it gets it right, is that the criminal justice system can be relied upon to get it right. There's a man in Philadelphia who almost bankrupted the city with his spectacular civil verdict after he was retried for a murder that he did not commit. And he was not successful on his appeal because his theory of defense required the police to be all in cahoots. So one set of cops are out there like beating a confession out of him, he says, and the other set of cops is planting bloody clothes in his apartment, and the jury didn't buy it, and the direct appeals court didn't buy it, and the habeas court didn't buy it. Nobody bought it, and then they ran the testing, and that was what happened. And so, you know, I feel like a little bit of a Pollyanna sometimes. You're like, surely not. And it's like, no, that's totally what happened. Is one set of cops were over here getting a false confession, while the other set of cops says that they went to his apartment and located, you know, bloody evidence that they did not get it from Anthony Wright. So how does that happen except by a really nasty set of bad actors that, like, you would never get a judge to buy into that. You would never get a court to buy into that. But that is what happened. And Anthony Wright deserves every penny of that money. He deserves more, frankly. But so part of what the Conviction Integrity Unit is hoping to do is to like show everybody sort of the outer limits of like how crazy things can really get, and that you really like the things that you never thought would realistically be possible because on some level you've bought into the system. Yep, totally happened. Probably still happening somewhere. So it moves the Overton window, I think it is, in terms of like your frame of reference about what's possible. So that's part of the hope, is that sunshine is going to be a little bit of a disinfectant, at least in Philadelphia.
Thanks, guys. So I think one thing that seems to be a parallel and has been sort of a through course from the presentations that we've seen is that Krasner's office has emphasized, justicial avenues for low-level offenses that prioritize therapeutic programs and treatment for substance abuse and mental health. And likewise, I don't think we've given you enough of an opportunity to really sort of speak on the holistic defense approach, but Bronx Defenders has encouraged defense attorneys to learn to identify mental illness, to work with substance abuse. And so I guess my question would be, how can prosecutors and defenders work collaboratively to off-road those cases where there's drug abuse or mental illness at the root? And how can both parties sort of account for mental health without vitiating the autonomy of the defendant, which so quickly, I think when it comes down to that advocacy role between prosecutor and defender, leaves the defendant out in their interests? And so I guess we'll start with Simmi.
Yeah, that's a really good question and a really hard question. So I'm generally wary of working with the prosecutor to find kind of a solution in that way, just because I think it becomes another mechanism for control, right? It becomes another standard of like, okay, well, I don't think your client is fully healed from like this like ailment that has affected them their whole lives, so I get to keep the terms going or whatever. But I think that the hardest cases I've had so far have been folks that suffer from severe mental illness, often that haven't been diagnosed yet and don't know that they do. So building trust in those relationships, figuring out what my role is supposed to be. I haven't had anyone that I've had to have assessed by the court and deemed incompetent yet. But my colleagues have, and I think those are really tough situations. In the Bronx, they just started a new court part called the Opioid Addiction Recovery Part, which...
Is it medication assisted? Are they doing medication assisted?
So they have the people assessed by Bronx Community Solutions, which is an in-court kind of like community program, and then they determine kind of a treatment plan. And the kind of perks are that at arraignments, if you agree to do this program, you will have no bail set. So it's immediately like super coercive, right? It's like otherwise we're asking for bail that you definitely will not make, and you'll be in jail. But if you agree to get treated, like you can do it. Cool. Sounds like it'll go great. So if you sign up for that, you basically have to come in like twice a week for multiple appointments. Whatever treatment they recommend is what you have to do. If you choose to say no, once you get notified of what that treatment is, your case kind of is restored back to where it was. They can ask for bail again, make a jail time offer. And the idea is that if you complete the full length of treatment, your case gets dismissed. I've had one person complete the program fully through. It was awesome, it was beautiful.
I think that's better than I did in 5 years.
Yeah. I mean, and this person, it was his first arrest. He had, where he was on the scale of addiction, like he had just started using. And he was inpatient for a really long time. Once, at some point, the organization, Bronx Community Solutions, even said that he's completed everything, we can dismiss the case now. And this judge, who was very hands-on, was like, I don't think so. Like, I'm gonna make him come back another 2 months, and I want to see what happens. And it's like, well, what if what if something happens after this? How long is this case gonna go on? And those are kind of the fears that I think motivate PDs when we're like, okay, is there another way to resolve this that doesn't put your mental illness or your substance abuse problem on the record? And I think it is sad because, sometimes people want treatment, right? And it sucks that often a lot of the programs that are available are only if the court mandates treatment to someone. And I think we should be creating spaces for that to happen outside of this social control mechanism again. But yeah, I think it's a question I'm still learning about. And in our office, we work with social workers. I can't diagnose anyone's mental illness, and I shouldn't. But I think, it's good to always make a referral. I'll be like, I'm facing these problems. I think this person is very paranoid, and I don't know what to do, and how to, assure them that I'm on their side, which I'm still dealing with. So, yeah.
Yeah, I mean, I agree with most of that. I think so many people that have criminal cases and have either mental health issues or substance abuse issues, and this is mostly coming from my time as a defender, they do not need to have their issues dealt with in court because it's a big stick. And a lot of times these are misdemeanor cases where under the normal circumstances, at least in the Bronx and Brooklyn, it's gonna go away, or it's gonna effectively go away if everybody sort of does things normally. Your run-of-the-mill drug case is gonna get an ACD. An ACD means you stay out of trouble for 6 months, you don't have to come back to court. You're gonna hear my spiel. You don't have to come back to court, you don't have to pay any money, you don't have to say you're guilty, you don't have to plead guilty to anything. 6 months from today, the case will be dismissed and sealed. I got really good at saying that. You should hear me take a guilty plea to a disorderly conduct, though. That's even faster. Those kinds of things, you don't want to tie up their mental health treatment with the criminal case. The criminal case is nothing. The criminal case is it's dust. But they need the mental health treatment. But you don't want to make that dependent. I would so much rather that people seek treatment in the community. They can get treatment that makes sense to them. And on the drug thing, I feel so strongly. Most of the drug courts of my experience do not do medication-assisted treatment. You have to be sober. I think rehabs in New York, you can't even smoke cigarettes. I think they're tobacco-free. I don't know if any of you guys have ever worked closely with people who are in active drug addiction, but cigarettes, you cannot ask them to be tobacco-free. It's asking too much for most of my clients. And I had people turn down drug court and go to jail because they could not commit to not smoking while they were trying to get sober. They're just like, that's unrealistic, I'm gonna fail out and I'm gonna go to jail anyway, so let's just get this show on the road. It's a nice example of public health laws that really end up not working for the community. But so drug courts in Brooklyn, at least when I was there, this was a while ago, you got arrested for having Suboxone. You didn't get Suboxone as part of your drug treatment. So anybody that was that had an opioid problem, I would affirmatively steer them away from drug court because it's not a good fit. You will relapse, and when you relapse, the court will come down on you instead of like people being like, okay, get back on the horse, like do it again, try again. It's mostly not worth it, was my experience as a defender. I found identifying substance abuse is pretty easy once you sort of get into it. Mental health, also, sometimes the facts of the case, like I never had anybody accused of breaking a window that didn't have a mental health issue that was pretty apparent. Those kinds of cases are not so hard to flag. When it comes to respecting somebody's autonomy, I feel like the thing about pushing somebody into treatment through the court is that, you know how so they're like, well, maybe this is a wake-up call. It's like, have you seen this person's rap sheet? It's 40 pages thick. Like, why is this the wake-up call? And like their last 3 cases this year weren't the wake-up call. This is the truth that I found was that people need to be ready. And when people are ready, that I had one like really successful client, like I didn't even do anything. First of all, he was not addicted to opioids. He just used crack. They every time did much better in drug treatment. But so like, he was just like, nobody really, I only ever got in trouble for like little stuff, and like the cops totally lied on me and are accusing me of like selling, but I didn't. But it's fine because now I'm getting treatment and I'm sort of into it. And like by the second court appearance, like everybody in the treatment court was like, oh, Jerry's the best. Everybody loves Jerry. Jerry's like snitching out other people in the treatment center that are like still using but not using names. He's so nice. What a good guy. So like in terms of respecting people's autonomy, I would always lay it out for them. Like, look, you're not going to get standard of care here. It's going to be coercive. You should not do this unless you are ready. You need to be ready. Don't let me tell you you're ready, because we'll figure out your case some other way. As a prosecutor now, I feel like for people with mental health issues or people with substance abuse issues, you would probably want to distinguish between cases where it's like the root cause of whatever brought them to court and cases where that's important. So like, you know, okay, so you drink too much and you get into trouble. Do you need to like seek alcohol treatment through court, or is this ultimately, is your trouble really not that big a deal and we don't need to address it through court, and you can address it on your own time with whatever sort of hopeful social resources we have available in some hypothetical world that of course does not exist. But the court ones aren't so good either, so don't worry about it, basically is my feeling. But I feel like as prosecutors, we have to be mindful that our only tool is incarceration, and it is such a crappy tool for all of these social problems. And when you come right down to it, that's it. That's all we've got. So it doesn't make sense to deal with this stuff in terms of the courts, because the stick is always going to be incarceration, and incarceration, in my mind, should only ever be for the utilitarian purpose of like preventing harm. And so I think it's pretty clear that it's not helpful to society to incarcerate, and it's not helpful to the person, because your mental health treatment in jail is always going to fall to the 8th Amendment floor. It's like, oh, your medical treatment just has to be good enough to not be cruel and unusual punishment. There's got to be a better option, not in the criminal justice system. It's shameful that like in any community in America, the largest provider of mental health services is the whatever the county jail is, Rikers Island, San Francisco jail. Like all of those are the largest providers, and when you think that that's the standard that they have to meet is the 8th Amendment, like, so when it comes, I think for the office, part of what Larry Krasner is trying to do is to acknowledge that he's the steward of massive amounts of resources. And so every dollar that doesn't get spent prosecuting somebody or incarcerating somebody or putting somebody on probation is money that is in the city budget for something else, whether that's public education, whether that's firefighters, whether that's community counselors who do violence prevention, or whether that's community drug treatment and mental health, which I think would be great. So that's sort of my mixed take on it.
I would just add one thing. I think it's like important to be said that people with mental health issues and illnesses are way more likely to suffer violence than to like do violence on anyone else, and I'm sure y'all are aware of that. And I even was like, even as I started talking about it, and this is what you do when you start doing the work and it becomes normalized, but the mental illness immediately becomes the problem, and this person is like the issue to be fixed, and I think that's like messed up. And also a reality of the system, right? And I know that as soon as like this person comes before the court as a defendant, they like their mental illness is the issue, and it doesn't matter if what someone is accusing them actually happened. It doesn't matter if they are consistently like due to their mental illness, like these situations arise because they are like victimized. So I just wanted to like check that in what I said as well.
I think that's totally fair. I found when I was a defender that it was far fewer cases than I ever expected to see. It's basically only cases where someone is floridly psychotic and they don't know, like, so once somebody starts telling you something that doesn't make sense, they're like, oh, at 4 o'clock I went to Europe, but then I came back, so I was back here at 5. You're like, when was that? Have you talked to a doctor lately? Like, that's, you know where to go from that. It's got to be somebody who's basically really, really psychotic and lacks insight and, won't give and take with you this idea of like, oh, do you take medications? Like, they're, somebody who's not hearing it, and it's a tiny fraction of the maybe, 1,000 plus clients that I ever represented, maybe three or 5 out of those fell into that category and should have had their issues like addressed as part of their court cases instead of alongside their court cases. That was my experience, at least.
And so now, just sort of in terms of what both of you have said about your roles sort of as they exist now, a lot has to do with sort of challenging the idea of the adversarial system. As it exists now, we basically have the power of the state on one side and largely indigent folks of color on the other side. And sort of, I think both of your roles are sort of breaking down that dichotomy. To what extent do you think that that's true? And to what extent do you think that sort of the limitations within your roles end up affirming that adversarial system?
I think the theory of adversariality, right, is that it's a truth-seeking function. It immediately becomes problematic when people lose sight of the larger context, and that's much more a problem on the prosecution side. And I will sing that to the heavens. But when I was in Brooklyn, one of my friends, one of my colleagues, had a client who had some sort of misdemeanor domestic violence case or something that was like not that serious, but the prosecutor was like being a real hard ass about it. And what ended up happening was that my friend's client was actually killed. He was killed in Brooklyn. So theoretically, the Brooklyn DA's office was the one that was responsible for prosecuting his killer. And in the meantime, the person, so like my friend shows up with his like obituary or his death certificate or something to try and get the case closed out. And she's like meeting with she's conferencing the case with the prosecutor beforehand, and the prosecutor says this insane thing. She said, well, there's more than one way to skin a cat. I was like, what did you just say? Do you want to put that on the record? Like, what are you even talking about? This is one of your victims now. Like, even if you have blinders on to the larger social context of how tragic it is that a young man is getting killed in Brooklyn because of rampant guns and whatever. So this is one of your victims now. Like, I'm sure your homicide bureau would not like to hear you talking about your homicide victims in that way. So I feel like that's what can happen when prosecutors lose sight of the broader context in which they operate, is they can overemphasize the adversariality. And I would never speak for that prosecutor because I don't understand that point of view. I'm sure if you asked her, she would just say, I'm just so passionate about victims. And it's like, he's a victim. What are you even talking about? But so I think it's very, very fair to say that prosecutors have relied on, it's an adversarial system for way too long, and have abdicated their larger responsibility. defense lawyers are just in a totally different spot. Defense lawyers, it's your client, and you gotta just go for it all the way. And as a prosecutor, I would never begrudge a defense lawyer for going hard. Like, it's not their job to break down the adversarial system, frankly. Like, give it everything you've got, because I'm the state, right? Like, if my job is to try and bring you to heel or something, I hope you get all the money in the world. I hope you get all the experts in the world, like, because the state shouldn't have any advantages. The state is the state. The person should have all the advantages. So I would never begrudge a PD for going hard, or any defense lawyer, frankly. I think that's part of the deal, because that's what you would want if you were the one that got arrested. But prosecutors absolutely need to forefront the societal part of their role rather than the adversarial part of their role. That's how I look at it.
Yeah, I think you captured a lot of that. I'm not giving up anything of the adversarial process. I mean, like you said, the full power of the state versus my client. Anything that infringes on the right to remain silent, the presumption of innocence, like, not doing it. And I think, aside from the reasons that you mentioned, what we see now is, like, with ICE, keeping an eye out on what's happening in folks' criminal cases. Even if we move to something more restorative or something that requires, like, taking accountability, and then my client becomes deportable, not doing it. So I just think that until, there's a restructuring of so much more than just, like, this relationship, we need to keep the adversarial system. I completely agree that I think prosecutors, and I see this in the Bronx DA's office, it becomes about winning, and I don't think it's about victims, because those victims are often from the same community that they don't give a fuck about. And if they were on the other side, they wouldn't care about them. I think it is about wins and losses, and I think that's not their job, and it's really harmful.
Yeah.
I'll keep it at that.
Yeah, totally with you.
So I think we'll just ask one more question. I know folks are getting restless for dinner.
Me too.
I think we've heard a little bit about the prosecution side and defense as well, and I think it would be interesting to hear what you guys think about it. I think the actor in the middle, the clerk, the judge. Recently, we had a Boston Globe expose here, an article drawing attention to clerk magistrate hearings where they were described as secret courts with few rules and fewer records. It's like the most boring 60 minutes. The article, it criticized unsupervised and perhaps unwarranted discretion that clerk magistrate hearings place in the hands of clerks. And reducing discretion, I think we're already seeing, may have the effect of making it more difficult to get charges dropped, with clerks less able to dismiss cases based on the equities. And so I would be curious to hear what you think the role should be for judicial discretion played in, whether it's clerk magistrate hearings or actual trials. What's the limit on discretion, and when can it be helpful, when can it be hurtful? And so, Sarah, I think it might make sense to start with you.
Yeah, I will totally own up to discretion being really tricky. When you limit discretion, you tend to get really punitive sentencing regimes, like the United States federal sentencing guidelines, which are terrible. Those came about as trying to reduce judicial discretion because of the concern that judicial discretion was resulting effectively in racial discrimination in sentencing. So it's this terrible toggle between no discretion, no equities, nothing, and oops, we gave everybody discretion and it turns out that everybody's totally racist, shocker. So it's really, there's no triangle point where, like, it turns out, so far at least, that, like, the equities are being considered in a non-discriminatory way. I thought the Globe article, I mean, this is probably the audience that, like, has the most perspective on the Globe article of any audience that I can think of, and it's just like, okay, I mean, the real problem is, as I see it, is the structure and the law around criminal records, because in New York, when things get dismissed, they go away. 99%, there's an asterisk there, but it's really, like, they go away. Whereas in Massachusetts, you want to get things dismissed before the person's ever arraigned, because once they get arraigned, that's their criminal record right there. And so it'll say, like, dismissed, but, like, your case is, when they run your record, it's not clear. There's something, it just says dismissed. And so if you modified that, I think then you could modify a lot of the things that the Globe had to say about clerks' hearings. I think they probably could be public records. I think that would probably be fine, right? It's only going to be the very, very curious people who go and like sit and watch. I think that would probably strike a pretty good balance, but I don't know why they're getting so head up about probable cause having to be shown. Like that's a good thing. We want every case to have probable cause, right? I think that's fine. And so I have no, I thought it was a little overblown, personally. But as far as the discretion and the judge, I don't have a good answer. Maybe it has something to do with like implicit bias training for judges. I don't think that the sentencing guidelines regime has shown that like limiting discretion has been good for people. I don't know. It was a kind of a weird article to read as a former defender, but Harvard defender rather than defense lawyer.
Yeah, I would agree with a lot of that. I'm also not of the view that like data and objective data is like free of any of these problems either, like you said. I think it can suffer from a lot of the same issues. I found the article really funny. I think it's like hilarious that it's always like this introspection like always comes at like the few pockets of like leniency we show in our system, and it's never on the other side. It made me, we have this judge in the Bronx, like a few years ago, he had released someone and not set bail on them, and they were suffering from like a mental health episode, and they hijacked an ambulance and like killed somebody. They ran over the EMT. Really sad situation. And the New York Post and Daily News goes crazy, and it's like, goes wild, checking my language. They go wild and they're like, oh, this judge released, this dangerous person, look what he did, bail should always be set, all these criminals out on the street, blah, blah, blah. The statistic for the number of people that get raped at Rikers every time they're sent there, like, is mind-blowing. 100% of trans people get raped at Rikers. 100%. Does anyone stop and go, maybe we shouldn't set bail on people? Like, maybe prisons are bad. That like reverse calculation never happens. Like, people die in jails all the time. Like, their lives are affected all the time. And it's just so freaking annoying. But you have to laugh that it's always when like one like slightly okay thing happens. And it's like, spoiler alert, rich people get away with shit all the time. Donald Trump is president. Like, Brett Kavanaugh's on the Supreme Court. Yes, like, probable cause hearings are not the battle that like we need to fight this at.
But they're secret courts.
Yeah, right. Even the non-secret courts, they get away with it.
Yeah,
so
right, they'd be fine anywhere.
the
They
deal?
would continue the arraignment, and it would be fine. They would be fine. Yeah.
That was my rant.
Yeah. No, it was pretty silly from where I'm sitting, but I don't know. I don't think anything would be harmed by making them have public records, particularly if you want to sit in a clerk's magistrate hearing all day. Be my guest, right? Right. We all do. I don't know. It made it sound like these domestic violence dismissals were like, oh my God, these domestic violence cases are getting dismissed. I don't know if this has been your experience. Those are going to get dismissed anyway. Every domestic violence case I ever had, unless the person was in jail, got dismissed. Nothing went to trial, ever. No, that's not true. Some people did programs. Like, if it really was dragging on and it looked like they were, if there was like a lot of pictures, then like some people would do programs. But like, family mediation is, a lot of times the mediation programs would be like, no DV, and everything would be like, no DV, no DV, no DV. DV is so much of what I did. It was a staggering proportion of what I did. And it's like, people don't hit strangers. Like, if people are going out hitting strangers, then they have a real problem. Like, people hit the people that are around them, which tend to be their family members. Like, that's what you need these sort of tools for, is domestic violence cases. But anyway, I have a very odd view of domestic violence cases for a feminist. But let's talk after.
Spoken like a true ADA. This was exactly the kind of contentious back and forth prosecutorial debate that we wanted, and so I'm glad we brought in those forces. But we won't keep anybody from dinner any longer, and so just can we please give it up for our two incredible speakers who've come so far. And so one more round of applause also for our Litman Fellows who worked all summer.
And you guys can feel free to ask questions to our speakers in the hallway. Is Daenerys here?
Yeah.
Okay, well, we have flowers for Daenerys. Everybody give Daenerys a round of applause. Maybe. Yes.